Hey guys, and welcome to today's video. Today, we have one of the wildest cases I've ever covered, where Judge Washington lets a crayon-eating sovereign citizen, Karen, know exactly how she feels about her.
You should seek some mental help because
I'm
something's
sorry.
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have
you
a
think
mental
the
problem.
laws of the
How?
United States don't apply to you and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make up?
All of it.
Now, I recently covered this Neander Karen, where she had her kids screaming in the background the entire time. Well, today, the kids are in school, and now it's her mother's turn to be schooled by Judge Washington. So let's begin.
Good morning. The 14B District Court is now in session. My name is Elaine Washington.
I find everyone's pain funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anise Battle, appearance, especially not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking, please.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Well, if it walks like a duck and it talks like a duck, then it's probably a glue-sniffing sovereign citizen. And as I stated in the previous video, her argument is that of constructive eviction, which is when the landlord of a property allows it to become unlivable, and therefore the tenant can vacate the lease without any repercussions. But as I also stated in that video, she's waived her right to claim constructive eviction by continuing to live in the property. She's still a ducking fuck though.
Well, whatever you're using as your basis is still not correct. It is not the law.
It is. It's still under
It's
MCL
not
and it's under the Landlord-Tenant Act.
overruled.
My objection is overruled, Your Honor.
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was
Because
rescinded?
that's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
My ruling, I'm not arguing with you anymore about it.
right, it's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to
Ma'am,
asking these
please
questions.
move
I will
on.
continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look at. MCL, what
I'm sorry.
was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
I love when they cite the law, because the lawyer is actually right. Under MCL 600.5716, the property manager is required to file a demand for possession in order for the landlord to begin the eviction process. So not only does she not know what she's talking about, but she can't read neither.
Yeah, have you read that statute?
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop typing. It says, a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay, that's fine. I didn't cite an exact statute, but I appreciate your objection.
Don't do drugs, kids, because apparently it causes you to forget what you just said 1 minute and 58 seconds ago. So let's refresh her memory.
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716. I just said MCL
Objection
because
is
they're
to-
both under MCLs. Both proof of service and certificate of service are both under MCL.
No,
Right, everybody, so
You,
let's not make my ruling.
like, let's just, okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
okay,
is,
ask that
is
question.
not on the disposition. And just like she read on 657, 16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no
It's
such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
And-
No,
publicly-
we're not publicly.
Well, you accept HUD housing. You accept HUD housing and you apply and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Ms. Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you
Please
objected
just
me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because
This-
it's not, that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just
I said either federally funded or get federal funds, which you do if you accept Section 8 and vouchers.
Yeah, and that may be true for landlord eviction procedures for people that receive HUD, but as they're about to state on the record, this dumb fuck isn't even receiving HUD. So whether or not she's living on a property that has HUD housing, those statutes don't even apply to her situation.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that, how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that
not a
these
debate.
are the
None.
requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing here.
Oh, you're getting a fair hearing. You just refuse to accept the fact that you're too stupid to understand why you are wrong. And it's not the court's responsibility to ensure that your stupidity deserves free rent for the rest of your life at the expense of the landlord.
Ms. Battle, move on.
Move on. So, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the property.
The court said that she had jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And again, this is why
you're trying to turn this into.
I'm not trying to turn into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
please move
all
on.
this is not right. And Attorney
I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against me.
Oh damn, it's not that often that a judge lets a window licker know that they have impending criminal charges for running the SovCit script and filing frivolous federal court cases and liens against her. And as an added bonus, because you know me and my team go the extra mile to bring you the complete story, I have a special surprise for you at the end of the video.
If you feel that it's frivolous, that's fine, but it's not. My rights are not frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut,
Yeah,
that would constitute as
cross-examination.
Battle, if
that
you're
would
not
constitute
going
as
to
the
ask
same
appropriate
type of
questions, then I'm
fault.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals because I don't know what you all are gonna do.
Of course you do, because this probably isn't your first attempt at scamming your way into free rent. And you just mentioned that the marshals are going to be getting involved. Well, I hate to piss in your paint chips, but it won't be the marshals, it'll be the sheriffs. And they'll be there to kick you to the curb so that the property can be repossessed. And this is the point when Judge Washington finally gets tired of her bullshit and tells her exactly how she feels about her.
You all have not been acting in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is questioned.
With you. I don't know what that is, but you should seek some mental health. Because something's wrong with you. You have you have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific. No, be specific, because now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right.
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action. And I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim. So having a valid contract is not an objection. Oh, because you're saying that because a notice was given and unrebutted, it's not of law.
An unrebutted frivolous motion is still frivolous and has no basis in law. So whether you agree or not, that's exactly what they are saying. And I know there are going to be people out there saying that the judge should know exactly what to do, when in reality, she does know exactly what to do. And that's her way of prompting the complaining attorney to ask for a directed verdict.
That's what you're saying, right?
Yes, that's not the law.
It is. It's the law. It's Wells versus Zendaya of Michigan. It is. It's
all right.
It's backed in case law, and y'all keep it's okay, because he can talk, but I can't talk.
Ma'am, you've argued that over and over, and I've ruled that it's not. You can file your appeals, file all the things you're filing, but when you file false liens against people, that is a crime.
It's not a false lien. You got defaulted on a private side, and you know that.
Okay, whatever. All right, so what I'm going to do is grant your judgment in this particular case because I've given her an opportunity to present the defenses that are real, and she has refused to do that.
I didn't refuse to present defenses. You didn't ask me about my piece of the case. I only got to cross-examine. You didn't ask me about my defenses.
What are your defenses, ma'am? And rescission is not one. I've ruled that it's not.
I'm sorry?
I know you heard me.
No, I didn't. You said, what are your defenses? And I didn't hear the last piece.
Your rescission is not a defense.
Okay, that's fine.
It is your defense.
Right, because, threshold matters are not an issue. But again, like I said, the fundamental objections and a counterclaim, object to the subject matter jurisdiction. You all accept and receive housing funds, making the subject matter.
Going down the same road.
Okay, listen, stop. I didn't cut you off. I didn't cut y'all off. You just asked me what my defense was. And
All right, I'm done.
Wow. You're asking me what my
The
defense is. I
defendant,
can't.
take her out. I've asked her 3 times to stop this. All right, I'm gonna grant your judgment in this particular case.
Your Honor, are you going to check the box after hearing?
Yes,
Thank you.
thank you.
I'm
Thank
sorry
you,
you had to
Judge
go-
Washington.
I'm
Thank
sorry you
you.
had to go through that.
All right, thank you.
Thanks.
Appreciate it. Bye.
Bye.
Well, there you have it. Judge Washington ruled against her, and the Mother of the Year candidate has just successfully caused her and her children to be homeless. You'd think she'd consider her kids before acting the way she does and just believing anybody on the internet. But she's a soft-hard Karen who cares about one person and one person alone, herself. Alright, so as I stated, I have a treat for you as we searched through the federal court database and actually found the frivolous civil action she filed against Judge Washington, Magistrate Braley, and others. I'll provide a link to all of the documents that she filed, but for the time being, I'm just gonna run through a few of her absolute dumbest claims. We will start with a filing on May 5th, 2025, directed towards the property. She starts by citing that non-existent entities cannot be party to a lawsuit. Well, according to the display of dumbfuckery we just watched, all parties involved do in fact exist. She continues by citing that under MCR 2.201b, a valid claim must be made by an identifiable legal person, and no such person is evident on the record. However, for a legally binding contract to exist in Michigan or any other state in the United States, there must be identifiable legal persons possessing the capacity to make such binding agreements in the first place. MCLs 440.1201 and 450.1261 would disagree with you that you or the property are not legal entities. What she should have cited was MCL 8.3G, the definition of an insane person. Nevertheless, if you aren't a legal entity, then you don't have a valid lease contract to begin with, and you're essentially a moldy couch left by a previous tenant that can be discarded in the human trash bin where you belong. Now we'll head to her next filing, which is as SovCit-ish as you can get, as the header reads, "Notice to principal is notice to agent, and notice to agent is notice to principal." This is also what she claims to be her notice of rescission. In this filing, she claims that under Michigan law, she is to be granted all payments, including security deposits, to be returned to her within 30 days. She also claims that even though the place is uninhabitable, she still requires the property to allow her to live there. And finally, that all parties must cease and desist from making any claims for a non-rescinded lease. Yeah, how'd that work out for you, dipshit? And finally, we head to her last filing, which was directly against Judge Washington, where she accuses Judge Washington and several others of violating her rights under USC 1983. I'm not actually going to go through all of her claims as they are numerous and idiotic, but I will share with you her demands for relief, as she is demanding a declaratory judgment, an injunction against the court from furthering these proceedings, and get this, $1 million in damages due to emotional, property, and constitutional harm. So yeah, Judge Washington has every right to bring up criminal charges under several MCLs, including 600.2907A2, which states that anyone who encumbers property through the recording of a document without lawful cause with the intent to harass or intimidate any person is guilty of a felony punishable by imprisonment for not more than 3 years or a fine of not more than $5,000 or both. Or she could bring criminal charges under MCL 440.9501A, which states that a person shall not knowingly or intentionally filing a false or fraudulent financial statement. And this violation is a felony punishable by imprisonment for not more than 5 years or a fine of not more than $2,500 or both. Now those are only 2 of several possibilities that Judge Washington could bring felony charges against this soft shithead. I guess what I'm trying to say is, she's fucked. Alright guys, that's the end of the video. If any of these charges are brought against her, there's a strong possibility that we'll be seeing her again in court. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.